Okay, hello everybody and welcome. My name is Bouvier Yulin and I'm the Executive Director for the Southern California Mediation Association. Thank you for joining us for today's webinar, What's a Court Appointed Neutral and Might You Want to Be One? Before I turn things over to our moderator, I'd like to share a few housekeeping items and some upcoming SCMA programs. Today's workshop is in meeting format, which means we can see and hear our participants. We ask that you please remain muted throughout the presentation. If you have any questions for our panelists, please feel free to place them in the chat and we will get to them. We will do our best to address them. I also want to highlight that there's an upcoming opportunity this coming Wednesday, January 28th at 12 p.m. Pacific time. We will be hosting our first Financial Strategies Professional Development Group meeting led by PDG leader Victoria Amini. While professional development groups for SCMA are typically reserved for SCMA members, we do allow non-members to attend up to 2 PDG meetings while exploring our membership. The session will feature representatives from Morgan Stanley discussing current financial markets and retirement strategies specifically for mediators. In addition, registration for the 2026 Virtual Family Mediation Institute will be opening this week. The Institute will take place on March 3rd through March 6th, and we'll be offering a virtual lunch and learn format with one workshop each day rather than a full day conference. So please keep a lookout for that registration. And finally, if you are not an SCMA member, we hope you'll consider joining. SCMA supports mediators through professional development opportunities such as this one. We also offer networking and resources designed to support and grow your practice. If you have any questions about membership or SCMA more broadly, please email us at info@mediation.org. And with that, it's my pleasure to turn things over to today's moderator, SCMA past president and ACAN member, Angela Reddock-Wring.
Thank you so much, Bouvier, and hello, everyone. So nice to see all of you, some familiar faces and friends and some new faces as well. And we welcome you to today's webinar, which I'm really excited about. So my name is Angela Reddock-Wring, and I am a mediator, a neutral with signature resolution, and have the privilege of having been a past president of the Southern California Mediation Association in 2019. And during that time, kind of shaping how today's presentation came about, during the time period that I served on the board, we developed a series called How I Made It. And I think that continues in some form today. But the series was really about meeting mediators and neutrals who were doing great work, who had established successful practices, and providing insights to all of us who, depending on where we are in our practice, to help us to grow our practice and to develop it and get some new ideas for ways in which we could engage as neutrals. And so in this last year, I've had a chance to become a member of the Academy of Court Appointed Neutrals, and which is a new world for me. And similar to my days in SCMA, as I, went on an effort to learn more about how to become a court-appointed neutral, and talking to Bouvier about that and wanted to introduce her to this organization, she immediately tuned in and thought this would be a great thing to introduce our members to, friends of SCMA to, and to help us all to see one additional path that we all might consider as mediators and as neutrals. And so that's part of the impetus behind today's webinar. And we're so privileged today to have joining us folks who have distinguished themselves in this work and are on the front lines of doing the work, everyday work of court-appointed neutrals. And so let me briefly introduce our panel members, and most importantly in the introductions, I am going to, before we jump into the core of our presentation, I'm going to ask them to give a 30-second elevator speech, so to speak, in terms of how they got into doing the work of being court-appointed neutrals. And so the first is someone who's quite distinguished, Deborah Greenspan, an attorney, but she's also a mass claims strategist and resolution advisor. Well regarded for her work in helping in serving as a special master, and you'll hear that that's there's been some development in using that term special master, but special master for distribution of the funds to over 100,000 Vietnam veterans. She's also the deputy special master for the September 11th or 9/11 Victim Compensation Fund of 2001, which is a $9 billion fund, and also currently serving as the special master for the Flint water litigation litigation matters. We also have Merril Hirsch, who is the first person I met in this world. He is the current executive director of the Academy of Court-Appointed Neutrals. He'll talk more about the organization as well as an upcoming conference in California, which Sid is serving as the chair of. Merrill's also distinguished in his law practice and currently serves as an arbitrator, hearing examiner, and mediator, in addition to his work as executive director of the Academy of Court-Appointed Neutrals and chair of the American Bar Association Judicial Division Lawyers Conference. When I think of Merril, I think of him as the person coupled with the organizations he's a part of and those who are part of the organization and really leading the effort to place court-appointed neutrals on the map and looking at the policy considerations, legislative considerations that impact the work that we do. So thank you, Momo, for the work that you do. And I know Deborah, you're past chair of ACAN, right?
No, I'm the current president of ACAN.
Yes, yes. So partner with Deborah and others. And then we also have Sid, who serves Sid
Kanazawa.
Kanazawa. He also sits on the ACAN board along with doing so many other great things. But what I appreciate about Sid's background as well is that has been a practitioner. One of the words you'll hear in this world of court-appointed neutrals is this concept of bellwether trials, and some of you may have done that in your practice areas, but led one of the biggest bellwether trials in the pharmaceutical industry and other work in what we consider the mass torts world. And Sid has spoken all over the country. If you look at his bio as a part of his work with the National Institute for Trial Advocacy, he's a leader in speaking on these issues and teaches at Pepperdine Law School, where many of us went for our training, our initial training as mediators and neutrals. So we have a distinguished group here. I'm really excited to have them and to introduce them. With the exception of Sid, he's not new to us, but to introduce you all to folks who I think might be new to our community of SCMA, Deborah and Merril especially. So with that, I'll just because the big question here is to introduce you to this world, but also to talk about how I made it, how I got there, what interested folks in this work. So I'll ask Deborah to just give us, quick 30-second to 1 minute insight about how you came to do the work and such distinguished work you're doing in this world of court-appointed neutral work.
It's kind of a hard question to answer in some respects. I think I got into it because an early project that I was working on, which you mentioned in the introduction, was addressing issues regarding the Agent Orange product liability litigation, which involved a huge number of Vietnam veterans, not only from the United States, but from some other countries. And I got involved in putting together a plan to address a settlement and to distribute the settlement and manage the settlement. And that and it was the first such program, mass claims settlement program. So I kind of got, very knowledgeable, I guess I would say. And then other things flow from that. And that was an appointment by United States District Judge Jack Weinstein, who was very active in a lot of very complex cases. So that was my first assignment in this arena. And that once you get started, you will find other assignments come to you. So,
Deborah, were you actively practicing law at the time, or were you a neutral at the time
no, I
of
was
that first
actually
appointment?
I was practicing law, and I still do. I'm still in a law firm. So
Okay. And you're based in what state?
DC, Washington, DC.
All right, very good. And that's kind of something. In California, most neutrals pick either they're going to continue practicing or go full time into neutral world. So it's great to see around the country that folks sometimes still do both.
Hybrid, yeah. Okay.
Yeah. So Merril, how did you get into this role?
I was venting 40 years of frustration in litigation practice. Because
How many people can relate to that,
I mean,
right?
every 2 or 3 years, I'd see across my career, they'd amend the Federal Rules of Civil Procedure. And if you look at the reasons they give for it, they say, well, we're amending this because civil litigation takes too long and costs too much. And, after they amended it all of these times, even I got the idea that maybe amending the rule just changes the terms of engagement and doesn't actually solve the problem. And when I thought about what did solve the problem, it was case management, and that made me think, well, why aren't we using this tool? So that's how I got involved in the ABA committee and eventually in ACAN.
And you're going to tell us more about that in your more formal presentation. So thank you, Merril. And Sid, what about you?
I backed into this. I took a course from Dan Simon in transformative mediation because I'd never heard of it before, and with the intent of learning how to negotiate. I was a trial lawyer for 40 years, and we did role playing, and I felt a change in my attitude toward my opponent, even though I'm just reading a script. And I thought, man, I got to find out more about this, and that's what started my interest. And then I attended an SCMA event and met a lot of people, and I attended an ACAN event and met a lot of people, and got very interested and found a community of people that were enjoyable to be around and were wanting to make a difference.
Excellent. And just as a little further insight, so what perked my interest in figuring out this world and as I continue on my journey is when we had the wildfires in California last year. And um, to those on the call who were impacted by that, our hearts continue to go out to you. But I saw this world of lawyers coming together, represent a lot of people, and like, what is this? Who are the neutrals on this work? Even Deborah have been following your work, not knowing your name, but just the work of the 9/11 Victim Compensation Fund. And it was through learning about who the neutrals are behind the scenes on these cases that sort of prompted my interest. Or even like the LA sex abuse cases, which Signature we're currently have the privilege of working on those cases right now. So that's when we talk about this world, those are the kinds of cases we're talking about, the big pharmaceutical cases, et cetera. So with that, Merril, let me pass it to you to kind of more formally introduce us to what is a court-appointed neutral, how we'll start the conversation on how one becomes one and telling us more about ACAN and some of its work.
Okay, great. I hope you all can see this.
And by the way, your presentation is perfect now in terms of how it's
Yeah, and I figured out how to solve it while you were talking. But
okay.
Great moments. Okay, what are we trying to do today? All right, first is understand what court-appointed neutrals are and how thinking about them has changed. The second is learn about what skills make for effective court-appointed neutrals. Learn about how you can go about becoming one, and learn about resources available to assist you. So with that, I'm going to start on the first one, which is really the background. So let's start with, what is a court-appointed neutral anyway? Well, is a court-appointed neutral, okay? Court-appointed neutral is a Swiss Army knife that can help avoid disputes in the first place, help resolve them, help provide expertise, help provide information, help convey and insulate, help ensure fairness, and help move dockets. By Swiss Army knife, think of it as a judge appointing someone to be neutral in a role that assists the court. So it could be the judge pulling his or her hair out in frustration at the parties and saying, I'm sick of your fighting over your discovery. I'm going to send you to your mother, court-appointed neutral, somebody, anybody but me. But it could be someone brought in to monitor a decree, or it could be someone to allocate a fund among claimants, or to make sure that claimants are heard, or to investigate a risk accountant, to investigate a trust and figure out where the money went. or an expert to help tell the court what's junk science and advise the court in going through that process. Or somebody is an expert in business valuation who can work with the parties on what information they need to figure out the business valuation. Basically, any type of neutral function that could be used in the court. And the skill set for it, it could be quasi-adjudicative. I've got these 30 motions, do something with it, do an initial order, will be reviewed by me, but it could be facilitated. Help the parties work out this e-discovery mess, okay? Help them figure it out. Use your expertise in e-discovery to help do that. It could be informative or using their expertise. Go out and find out this information or tell me about this. It could be investigative. It could be an intermediary. The parties are negotiating settlement. The court doesn't want to know what they're saying in settlement, but the court may benefit from knowing that if you just decided this issue, it would really assist the case. So someone can go between. Could be someone looking at a privileged log so that the judge who's hearing the bench trial doesn't see the memo from plaintiff's lawyer saying this is a dead cold loser, don't bring it. It could be implementing, helping to implement or monitor a decree. It could be broadening and supporting. ADR skills support courts. They are different skills from the skills a judge can use. A judge can't do all the ADR functions because the judge ethically needs to be there to wear a robe and decide things. The judge can take advantage of those skills. All right, so where does this all come from? Here's a history from the beginning of time to the current form of Rule 53. This is the federal rule in about 20 seconds. This, as you all know, is William the Conqueror. It is believed that the use of court-appointed neutrals came over to Anglo-American law with the Norman invasion from France. If that's the case, then the use of court-appointed neutrals in England predates the use of English. That's how old this is as an idea. It goes back in the United States, the first case filed in the Supreme Court appointed a bunch of neutrals. And more recently, 20 years ago, they amended Federal Rule 53 to make it close to what people were using. And there's a plurality of states. There are a couple that you could argue don't permit it, but basically the vast majority of states permit it in some form, including California, which has statutes on this. So in 2016 or so, the American Bar Association Judicial Division forms the Lawyers Conference Special Masters Committee. That's what it's called at the time. And incidentally, Angela slightly misspoke about my background. I am not the head of the Lawyers Conference. I'm on this executive committee, but I don't run the Lawyers Conference. I run this little committee within the Lawyers Conference.
Okay, thank you.
But the idea of this—
trying to promote you. Elevate you.
The committee formed a working group across 10 of the ABA divisions, sections, forums, people doing all kinds of things, not just neutrals, but it included the dispute resolution section. It included practicing lawyers in numerous different fields and judges and others. And the group met for 18 months and came up with consensus guidelines on the appointment and use of what we were then calling special masters in federal and state civil litigation that the ABA House of Delegates approved in January 2019. So what are these guidelines? This is actually the first guideline, and it gives you a sense of what the thinking is. So the first guideline says it should be an accepted part of judicial administration in complex litigation and in other cases that create particular needs that a special master might satisfy for courts and the parties to consider using a special master and consider using not only later in the case, but at the outset. Now, if you think about this, you'd think it's completely unremarkable. I mean, a court should consider using this tool if it's useful. It's almost a tautology. But actually, it was a different way of thinking because historically, although this tool has been around for potentially 1,000 and arguably goes back to Roman law, so thousands of years, people think of it as something weird. It's special. It's strange. I wouldn't do this. I wouldn't think about this. And people simply didn't think about it as a tool you could use if it's useful, don't use if it's not useful. And just saying, think of this as a tool. And now let's talk about how we can make this more useful, how we can use this as a practical matter leads to all kinds of very important things in the change of thinking. For one thing, if people are more familiar with the idea of using it and expect it to come out, they'll think more about the many different ways it could be used and be more used to it. If you're considering it as a more regular process, you can do a better job of picking people to do it. You could set up rosters or regularize it. You could vet people properly. You could train people properly. You could evaluate their work and make it better. And so the guidelines focus on how can we improve this profession? And ultimately, it talks about having local rules and practice to perform a broad array of functions with a referral order that describes it. Okay, so that committee that's still called the Special Masters Committee goes back to implement the guidelines, and that leads to ultimately 2 resolutions. One of them, 2 more resolutions that were approved, the ABA approved in 2023. All right. One of the things the committee realized is if you want to get people to use this tool and understand it, give it a better name than master. I mean, like master has a horrible, background, of course, that we're all familiar with. Plus, even if you put that aside, who wants to have a master of St. Bernard? I mean, it's a horrible name, and it describes someone who's brought in to take over. That's what it sounds like. But actually, it's someone brought in to help. And so if you want people to understand that this is something to help, stop using that term and come up with a term that at least describes the job. So we went through dozens of possible names and ultimately came up with the idea of court-appointed neutral, which is accurate. I mean, it describes the Swiss Army knife. And what we're trying to do is brand that as the name. And so the ABA supported changing the guidelines themselves, laws, rules to use this name. That's this resolution that they approved in August 2023. And then another one, the ABA went back to the guidelines and in detail went through them and came up with a model rule designed to implement all of their precepts. So there's a model rule you can point to. Now, the idea is not necessarily, it's a very long model rule, it goes on pages and pages, but the idea is to use it as a starting point to understand how it's used and how states use it. Then the ABA went back to the federal rulemakers and said, okay, you got to change this name in the Federal Rules of Civil Procedure so we can use court-appointed neutrals. And also, there is a much longer story than I have time to tell here, but there's a Bankruptcy Rule 9031 that was adopted in 1983 to prevent the use of neutrals in bankruptcy proceedings. It says, change that rule, allow them to be used in bankruptcy. So they went back. Those rule changes are still pending with the federal advisory committees. Then the committee went back. It worked on ethics. We just did the first ever all-day program on court-appointed neutral ethics just last October. Developed criteria for selecting neutrals to a roster. Developed a survey instrument to evaluate neutrals, and resource and checklists for using neutrals in the pandemic. Meanwhile, you've got this organization, the Academy of Court-Appointed Neutrals now, was Court-Appointed Masters. It changed its own name, and it picked up where the ABA kind of stops to broaden the profession itself. So the idea is to open the profession to people who had not previously served, and to diversify the profession, bringing in people with a broader background, so it's not just repeat players. They revised a bench book that they had for years to have a tremendous guide on how to use court-appointed neutrals. That's a publicly available document on the website. Developed a statement of guiding principles so that people know if you're using a neutral who's part of ACAN, they're subscribing to principles. Developed training, developed an incubator program, the New York Law School program I mentioned, and then partnered with dozens of organizations. Dozens of organizations to help to get the word out, do programs, develop opportunities for people, and to make this more a part of the public discourse. Okay, so that's where we are, at this point by way of background. Now, the next topic is what skills make for an effective court-appointed neutral. Debbie, do you want to talk some about that and how they're used?
Well, we're going to pick back up on that with Sid. we'll turn it to Deborah now to give, building on what you said, to give examples of how court-appointed neutrals are actually used and in what types of cases, and then we'll circle back to this.
Okay. Thank you. First of all, I want to say thank you for having us here. It's great to meet everybody and to see everyone who's on. I also want to tell you that I got a little message that my internet is unstable. So if I just freeze, that's why. Anyway, it seems okay right this minute. I'm just going to give you some examples of things that I have done. And it is not, I think that the tasks can range. There's a huge variety of tasks that a court-appointed neutral can perform for a court. And I think when you see some examples, you'll see why it makes sense for a court to appoint somebody, because these are tasks that may require a huge time investment or something that the court with hundreds of cases on their docket cannot always devote that kind of time to specific issues. So it comes in I would say mostly what I've been involved in is complex litigation and mass claims litigation. So I mentioned that the first assignment like this I got was in the Agent Orange product liability litigation, which was a multi-district litigation in the Eastern District of New York. It was huge. These were Vietnam veterans suing for various physical ailments that they alleged had been the result of the use of herbicides during the Vietnam War. And so one of my tasks was to figure out, we had 5 million class members. And one of my tasks was to figure out a distribution program for a settlement. And then to figure out actually how to make it work. And it was very multifaceted. And I'll just give you one piece of the puzzle here, which was a screening mechanism for a settlement, which in that case was, were you actually exposed to this herbicide? So how do you figure that out? And so I ended up with a combination of military historians getting access to Department of Defense troop movement documents and getting access to the aerial spray missions in Vietnam, which were mostly carried out by in the air, although there were some other kinds of herbicide spray missions. And so we developed a process to place people, figure out where people were, because we had those military records and we had the spray missions, and then we could sort of put them together and see if people were in the vicinity of the spray missions, and that's how they became eligible for compensation under the settlement. So it was a very fascinating and something that it took hours and hours and hours to put together. There's no possible way that the judge could have devoted that kind of time personally to creating that sort of system. And then, of course, there was a regular, that maybe people are very familiar with. People submit claims, and then they are determined whether they meet this screen, and then they can get their compensation. We had about 105,000 eligible people who got paid through this compensation program. So that's just one example. It's sort of developing what's going to work, what's going to make sense, how can you get the data that you need to get in a particular situation that was kind of overwhelming. How would we distribute money to all of these people and figure out who actually should receive the funds? I'm currently working, as you heard in the introductions, on the Flint water litigation, and I want to give you a flavor of some of the things that I ended up doing in that case, because it was a combination of litigation issues and settlement issues and mediation issues. It was sort of multifaceted, I guess.
Oops. Is this where we possibly, can you all hear me? Did we all lose Deborah? Okay, she may have to log back in. Sid or Merril, oh, there you go, Deborah. You went out for a second.
Did I freeze? Okay.
Yes, right about when you were going to tell us about your Flint litigation
Okay, I'm so
case.
sorry.
No problem.
I can't tell actually that it's doing that. So in that case, I had a variety of assignments. I think I mentioned that. I don't know if you heard that part. And it ranged from creating reports and recommendations to the courts on legal issues, motions that were filed and needed to be resolved, to assisting the parties in coming up with a viable settlement structure when they were interested in talking about settlement. And the structural part of it was very important in this case because we had class actions and individual cases, and it was a question of how to merge those different types of legal vehicles into a settlement structure. And so that was a very big part of my function in the early phase. But the very first thing that I did was to develop the census, which is who's out there, how many people are out there, how many people have contacted lawyers, what are their characteristics. You can't actually proceed to even manage the litigation without having some sense of what you have in front of you if you're the judge. And there were a lot of people who had not yet filed cases but had engaged lawyers, and they were waiting in the wings because there was tolling, because the class actions had been filed and the statute of limitations was told. So they weren't filing until they saw how things progressed. So it was a complex process, but it was essential because you couldn't proceed with managing the litigation. You could not proceed with discovery. You could not proceed with any kind of settlement discussion without understanding the scope of what you were dealing with there. But what was more complicated even about this case is that it was proceeding the same time as criminal actions against the same people who were defendants in the civil cases. So a lot of them were not participating in discovery, and the state of Michigan, the entities that were public officials, and I guess I should back up and simply say that a lot of the defendants were public officials, claimed qualified immunity. So there was a question about whether you could even proceed. And so part of this project was to figure out how to proceed in a logical fashion that would bring up the issues that were sort of critical to determining whether this case could proceed forward or whether it was going to have any legs at all. So that happened first, and that we could then organize the discovery process. So it's a very, you have to understand the case in order to understand how to proceed, and you have to see the volume of the case in order to proceed. So there's a whole lot of different assignments, kind of combined within that general description. But your projects, the work as a court-appointed neutral can range all the way from a purely legal analytical assignment where the judge simply submits something to you for a report and recommendation. I think Merril mentioned privilege logs, there's discovery issues, but they're very important to the litigation, and you can make a report. And this does not there's always a question about whether that slows down the litigation because it's a two-step process. The court-appointed neutral makes a recommendation, and then the court has the opportunity to make a decision if somebody objects to the court-appointed neutral's report and recommendation. So, but I don't think that it does because the court-appointed neutral pulls everything together for the court. And it is a neutral and objective process. It's not an adversarial. I mean, what the neutral provides to the judge is informative, not the two-sided arguments that the judge then has to wade through. So all of that is done for the benefit of the court. I have presented many reports and recommendations. I've never had an objection, except for the very first one that I did, which was an order on the census, but that got resolved pretty quickly. So if you're careful and thoughtful and you understand the positions of the parties and you can develop something that is supportable and supported, then it will bring the litigation forward. I don't want to take up all the time. I want to keep mindful of Sid. Sid has comments to make, and so are we still on track on time, or should we?
Yes, we're good. And maybe just tying up your piece for a second. So in terms of the types of cases where you might find a court-appointed neutral, are these only in federal court primarily, or it could be state court also? And it tends to be high stakes litigation where numerous people have been impacted, such as the 9/11 or the veterans or Flint, Michigan that you're working on? Are those really the only kind of cases
No,
where we see this type of work?
It's the only kind of cases, and it is not only in federal court. But I do think that because there is a cost to having a court-appointed neutral, that the case has to be significant enough to warrant that cost in some respect, whether it's significant from a very substantive perspective or from the amount at stake. but I think that's part of it because, again, because there is a cost to bringing in a third party who's not an employee of the court system. I will mention one other thing, which is I do a lot of court-appointed neutral work in terrorism cases, and these are cases which seem to be growing in number, but these are cases seeking compensation for people who've been victims of terrorism. And I won't get into the complexity of all of the statutes that are involved and all of that, but there is it's a pretty I do a lot of that, and that is more the purely it's developing a factual record, and then it is determining the appropriate outcome based on the case law and the statutory law. So it is it's like a totally judicial function, really. But it's done by special masters or court-appointed neutrals because they're incredibly time-consuming to put these together. So I will stop there. Turn it over to
Okay, thank you. And just who pays the costs for neutral, court-appointed neutral? The lawyers or the parties?
The parties typically pay the cost. In the terrorism cases I mentioned, there is a fund in the Department of Justice that pays, but it doesn't pay a ton. So don't think of it as something that you can do and live on, but it has its other rewards. So
Excellent. Merril?
Just one comment on that. Historically, and what Debbie is saying is exactly right. Part of what ACAN is trying to do is broaden the use of this tool to areas where it hasn't been used as much historically. We're going to be doing a program for the National Council of Juvenile and Family Court Judges at their annual meeting on using court-appointed neutrals in child welfare cases. Part of the model that we have talked about is if you set up rosters of neutrals, you could have a pro bono commitment from the roster. So they could be used in cases where the parties can't afford it or they're not case specific. So there are ways that we're trying to work creatively to broaden the tool to make it available, not just to people who can afford to pay for complex litigation, but a much wider array to help deal with access to justice and other issues.
Excellent. Well, that's a good transition to Sid. Sid, you're going to give more insight on what skills make a more effective court-appointed neutral, but if you'd like to weigh in also on the types of cases maybe you work on or that you're aware of where these opportunities are available.
Debbie's being very modest. She worked with Ken Feinberg on the 9/11 cases and a number of these mass settlements that could not have been achieved without people like Debbie that was figuring out how to process all these things in a timely manner and a fair manner that everybody would walk away feeling satisfied with the resolution and all that. And Ken Feinberg is actually one of the founders of ACAN, and so it's originally in that context, and now it's being brought into to address a much broader scope of cases. As far as
the SCMA actually honored Ken Feinberg, I want to say around much earlier in the 2000s. I remember that was one of my first SCMA events. So Bouvier, we should look into that, what year that was. Thank you, Sid. Go ahead.
And what ACAN or the neutrals and the court-appointed neutrals and all that really addresses is the problem we have where we have courts in the LA Superior Court. The judges have now instead of caseloads of around 400, which is the optimal number, they have caseloads of over 1,000 per judge. And so they're overwhelmed with cases and trying to process those cases and really clear the way for cases that should be tried. At the same time, we know from statistics, not just in Los Angeles, but across the country, that 98 to 99% of the cases will somehow be resolved outside of court. In other words, it's not a jury or a judge that's making the determination of those cases. 98 to 99% of them are outside of the judicial process. They may continue through the judicial process, but they are not decided by a trial or a hearing or anything of that sort. And as a result, the neutrals attempt to fill in that gap, to figure out how to get these cases resolved faster, so that we can take them out of the system and open up the highways for the cases that need to be tried and should be tried in this process, so that we can speed up justice and provide greater access to justice for all the people involved. When you're talking about these very complex cases, there's another aspect to them as well. And that is that a judge has to make a determination. The judge has to be very neutral and has to listen to two sides that are arguing two sides of the case, and has to be neutral. But as we all know, problems are not necessarily binary, that problems are often very much more complex and need to kind of, sort through all the details. And as a result, the neutrals that are involved in this process are doing things that the judge cannot do. And that is to talk to one party without the other party. That is to talk to the parties in a humble fashion, not determining and being an overlord of what you should do and telling them what to do, but rather as more like a mediator who is listening to everybody and trying to help the parties hear themselves and help them to figure out how they can work together to try to find a better solution together. In other words, how to collaborate as opposed to be advocates and opponents of each other.
Excellent, excellent. Merril, did you want to briefly bring back up your screen that added to some of the qualities of a court-appointed neutral? And then we'll turn to sort of the big question of, if you're interested, if any of this conversation piques your interest, what are some ways you could go about trying to add being a court-appointed neutral to your practice?
Okay, can people see that?
Yep.
Okay, so why don't we talk about this? Sid, do you want to talk about what skills make for effective court-appointed neutral for a second? And then, I mean, we talked about it to some extent, but what makes them better at the things you described?
Well, I think the primary thing that we do as neutrals is we listen and we can talk to people individually as opposed to all together. And a court is limited in what they can do. And I think that the difference in terms of being a court-appointed neutral as opposed to other settings is that you represent the court. You represent the court, and therefore you have to conduct whatever proceedings in a way that everybody will think is fair and effective in terms of resolving the problems. And so the skills that are needed are all the skills that you have to have as a mediator. But more importantly, I think that you got to be creative. You got to be really creative, because what you're doing is offering solutions that people might not otherwise appreciate. How to resolve 1 million cases as opposed to trying them one by one. And you have to be creative in terms of figuring that out. When I was a trial lawyer, we had a big oil spill in the port of Los Angeles. And it's much more complicated than I'm going to tell you, but basically, 2 days after the spill, we had an angry mob that was ready to lynch us. I represented one of the ships. And, just by listening and asking open-ended questions, we flipped this crowd, angry mob, into collaborators. And we settled 600 of the 2,000 claims within 2 weeks of the spill, and all 2,000 within 3 months without any lawsuits. And that's the kind of thinking that you have to, it's not litigation, it's not adversarial, it's not fighting about facts and rules and treating the other side as an enemy. It's figuring out how do we get everybody to be on the same side of the table and solve the problems as opposed to fighting about the problems.
Excellent. Thank you. Deborah, Merril, did you want to add to that? If not, I recommend we transition to what are some ways folks can think about becoming a court-appointed neutral? And Merril, want to make sure you also highlight the upcoming ACAN conference. Who
Also,
wants to take that
I
first?
saw a question pop up too in
Oh,
the, I don't know where it is, but
okay.
the answer is no, you do not have to be an attorney to be a court-appointed neutral. That was the question I think that I saw.
Okay.
But I think Sid, that's a very great overview of what we're talking about. Really, you're acting like a judge, but with specific assignments and with a kind of a mandate really to as Sid said, be creative and help the parties with issues that they have that don't need to tie up the litigation. You can't move the litigation forward because you're stuck on something, and can we get over this hump so that we can continue to move forward? So but there's just so many components to this, and some of it has to do with your type of experience and knowledge. That's helpful too. But I think we should transition to the how do you become one? I think that's of interest.
Why don't you kick off Merril, do you want to kick off that conversation or
I can
Deborah?
kick off that
Okay,
conversation.
great. Thank
Okay.
you.
All right. Rule number one, join ACAN. Oh, actually, I kind of mean it. It is the purpose of our organization is to help people become court-appointed neutrals, to help court-appointed neutrals become better, and to help them better serve the administration of justice. And you know that's true because it's on the back of my business cards. And so a lot of what Debbie and I spend our time doing is what creative ways can we create new pathways into this profession that no one's ever done before. So we have, and what tick off a million, all of them, but we try creatively to come up with ways where people can publicize themselves and have people know about it. We have a very communal organization. We help people get their word out about themselves. We repost things. More generally, get involved. Get involved in a local program at your court to help improve the administration of justice, to help people. We have an How Can ACAN Help program, but individuals should get involved in their local courts because that's how they figure out the problems. Use your ADR skills. Ask questions about what the needs are and see if you can work creatively to help solve them. You're both being a court-appointed neutral and serving the court simultaneously. So there are many opportunities for being involved in programs. ACAN will support people and give them information that they need or help them get projects or programs or presentations. But a lot of it is to go out and meet judges and ask them what their problems are. Another big thing which Angela has kindly mentioned is we're doing our annual meeting in Berkeley this year. And our annual meeting is a get-together. Picture court-appointed neutrals at the intersection of ADR and courts, and picture everybody affected by that. The ADR community, the judges, the court staff, the stakeholders in the litigation process, the vendors who provide information, academics. Our annual meeting is a place where those people come together and people get to meet each other in a completely different way and talk about these creative solutions. So there's a lot of stuff, and we'll get to resources that at the end of things. We have a lot of materials on our website. I'm happy to talk with anybody to give you more insights in them. So do you want to add to that, Debbie or Sid or Angela?
I would just add that the members of ACAN, one of the really great benefits of getting to know people is that they are resources. You get an assignment, you've never done something before, you run into an issue, everybody will jump in to tell you whether they've encountered the same kind of problem. It's kind of a very collaborative group. It's not like people are getting involved in your case, but if you have if you have something you're curious about, people will help out. They'll give you the benefit of their experience. So that's one of the things at least I've seen in this organization. It's very useful that way.
And the organization is codified to a certain extent what they've learned. They've got bench books and things like that that provide samples of court orders and things that could be issued in order to implement the court-appointed neutral situation and all that. But I think this is sort of like a new industry, a startup kind of platform here, because in large measure, I don't think the courts or the parties or anybody else really knows all the ways in which we can move our system of justice faster and fairer in order to free up our judges and courts for the cases that should be tried. And I think that that's where creativity is an important factor. And so we have incubator programs at ACAN that help you to gain the skills and to develop the contacts to become a court-appointed neutral. But you still have to add that creativity and ability to figure out how do we help the court as best we can.
Yes. I see a couple of questions here, and we'll get to those in just a second, but just want to, so Deborah, you're still in private practice. You got your first opportunity many years ago. Or you just sitting in your office and you got a random call to say, we want you to be a part of this litigation, and especially since this is still an evolving world and it's not, at the forefront of everybody's mind to find a court-appointed neutral. How Any more insights as to how you got on your path? Because I think of all of us, you're doing it at a very high level.
Hold on one second. I'm so sorry.
Okay. And
Okay, I'm
okay.
ready. Sorry, I just got a call that I needed to say. I'll call you right back. So you actually go out and meet people, and that include, you attend conferences, meetings, you get to know people who are, involved in cases where there might be a need for a court-appointed neutral, and you get your name out there just like any other type of work that somebody does. If you're a mediator and you want your name out there, you join organizations, you get that kind of credential, you are able to publicize yourself. There's no difference here really. But you may get, I got a particular assignment that's extremely challenging and rewarding simply because a judge who was not involved in a particular case, but that I knew from another case, recommended me to the judge that was in charge of this case that I've now gotten involved in. And it's something I did specifically, but the recommendation came because of some experience. And that's just like I think how people get more mediations, because somebody they recommend you because they have used your services. So that's part of it. I think what Merril talked about in terms of rosters and the ACAN sort of member list, people can go to the ACAN website and find people who are court-appointed neutrals. So a judge could go there and say, I'd like to find somebody who might be suitable for this particular case. And if courts develop rosters like we see we have rosters of mediators in some courts, that's another way in which people could become somebody who gets selected for these. So we're trying to build those avenues for people. But it's like anything else, it's multifaceted and also it's becoming known as somebody who's eager, wants to do this, and who maybe has some experience. So
thank you. I think I see a question about the conference. I think Merril answered that in the comments, and he also has a slide on it. Technology, Merril answered that question as well, and how to get more involved. The panelists just gave some insights about that. Laura is looking for a parenting coordinator, someone doing work in that area in Southern California. So definitely if you have any connections there. And yes, Tom, the slides will be provided. as well as information about the upcoming ACAN conference. So I see we're at 3 minutes from our time. So Merril, why don't, if there's somebody with one more question, go ahead and quickly put it into the chat. If we can respond, we will. And then Merril, why don't you share the slide on the ACAN conference coming up?
Okay, I'll share. First of all, there are two things. These are all sorts of information. There's a website for the committee at the ABA. ACAN has a lot of stuff on its website, including this bench book, which is like a point by point going through stuff, and a training and mentoring program. Plus, as Debbie mentioned, when people become members of ACAN, they post profiles, and you can search by location or expertise. You can find people there, and people can find you if you become part of ACAN. It's kind of a national roster. This is our annual meeting slide. It's a really cool picture. Our annual meeting is at the International House on the campus at Berkeley. Sid has done a magnificent job putting this together. Our speakers include a who's who list. It includes the Chief Justice Colin Seitz, who's the president of the Council of Chief Justices. It includes the director of the Federal Judicial Center, includes Erwin Chemerinsky and Judge Jeremy Fogel from Berkeley, a number of other judges, a number of other spectacular practitioners, and it's a terrific meeting, and so much so that my cat is excited about it and about to jump up. So, and here's a link to it. The slides are going to be available. Just click on the link. You can find out more about the meeting, what's going on, and when it is and what to do. And you can also contact us.
Wonderful. And maybe we can still explore some other ways, Bouvier and Merril, for SCMA and ACAN to partner together. What I will just add is, someone, as many of you have been in terms of helping to build the neutral programs, the mediation programs in the court, and to make sure the courts are thinking about mediators and allowing us to help establish courts, our programs within the courts. This is sort of a new frontier or an extension of that. Like, we've done a lot of work in Los Angeles and California to make sure mediation is a part of the court. But this is, as I think Deborah commented, we're actually working for the court in this type of work. So I think this is a new frontier of conversation to have with the courts in California and Los Angeles to see where these opportunities are. And from the lens I've discovered already, that seems to rest in Los Angeles, at least at the moment, with the judges that are heading up the complex litigation courts, right? And the lawyers that appear before those judges. So it's a cottage industry, but I think there's opportunity, or there should be opportunity, and we should be encouraging opportunity to support our court system in this added way as well. So looking forward to being a voice and seeing how I can, be a voice, joining with many of you to make sure California, that we're representing as well in the court-appointed neutral space. So with that, I'd like to thank SCMA for allowing this opportunity to expose our members to this work. I'd like to thank our panelists, who are all distinguished in this work and in this field, and hoping that you all got a lot out of today. Granted, it's just an introductory conversation for many of us, but hoping that you, like me, will be, joining in to explore this work and world even so. And see you at the ACAN conference in March.
Thank you so much.
Thank you, everyone.
Thank you all. Great presentation. Thank you so much. And thank you
you.
for everyone for taking time out.
Bye-bye.
Thank you.